other stakeholders. When I was born nearly 3 decades ago on the African continent, many African countries had democracies that were less than 3 decades. At the same time, many African countries were still being colonized. Today, in Africa, within the African Union, there still remains many institutional and political challenges. My name is Moses Gashira Bakke, and I am a survivor of the 1994 genocide against the Tutsi in Rwanda. And the previous speakers, Dr. Small and Dr. Eltis, spoke to me directly. And hate speech is one of the most challenges of democracy, and how you balance freedom of speech and the ability for people to respect one another. So as a genocide survivor, that does not define me. Today, I am also a graduate of the Faculty of Law at McGill. And one of the challenges that I have gone through as a survivor of the genocide is reconciling the ability of those who deny the genocide and those who want to threaten peace and security, especially on the African continent. So today we are privileged to have a scholar who also is a graduate of the McGill Faculty of Law. And she has also studied extensively on refugees issues and migration. And this is Professor Dr. Marina Sharp, who is a Steinberg postdoctoral fellow of international migration, law and policy at the Faculty of Law at McGill University. Yes, and so Dr. Sharp is also earned a doctoral in law at Oxford, and she also is a Trudeau scholar at the same time when she pursued her PhD at Oxford. So prior to her studies at McGill, she practiced law in New York and London and worked as a refugee rights organization, many refugee rights organizations in Uganda. So she has also worked for Amnesty International and also the European Bank of Reconstruction and Development as a consultant. I've been informed that Dr. Sharp is back with us. And on the program as well, we had the Minister of International Affairs. Unfortunately, she could not be with us today. But I'm really, really excited to hear from Dr. Sharp in terms of how the African Union has moved from non-intervention to non-indifference within the responsibility to protect framework. So without further ado, welcome to Dr. Sharp. Thank you.
Good morning. So I'm very sorry to disappoint the chair, who said he was interested to hear me speak about the African Union. Last night I changed my mind about what I was going to speak about because I prepared to talk about the African Union, and then I ran through it with my and he told me he had no idea what I was talking about at the end of it because there was so much background that you would need to understand to kind of take it to the next level of what is the African Union doing that he, as you know, a non-specialist didn't have, and so I got a bit worried about that because I like to think that my husband is an intelligent individual, and so I decided to just actually give you that background. So I'm going to talk to you today about the law, specifically the responsibility to protect, and I'm also going to give you some background some international law background that I think you'll need to understand the responsibility to protect. But I do know quite a bit about the African Union, so in the Q&A, hopefully, if there are people who are interested in that, feel free to ask me. I'm aware in talking about relevant international law to prevent international crimes and the responsibility to protect, there are some people in the room who I won't be telling you anything you don't already know, but so please indulge me, and I really want to try and bring everyone in the room with me. Before I do talk about the law, though, I think that one point I want to make, as someone who works on international law and international human rights law, I often find there's a danger when you focus only on the law of kind of disconnecting from the humanity that the law is seeking to protect. And for me, as someone working on law, I find it always important to kind of reconnect with the human issues, the real human concerns that the raison d'etre for this body of law. And I think, looking at the program of this conference, I think it's great that I see in the program an acknowledgement of that through including things like survivor testimony. And I try always in my work to kind of every so often reconnect with the human issues underlying the law. Otherwise, there's a danger of doing what Payam Akavan calls reducing genocide to law. That's the title of his book, and that's something he talks about in his book. So we heard from Charles Small. He talked to us about his aha moment when he was having coffee with survivors of the Rwandan genocide, and I had my own aha moment a couple of weeks ago, which I'd like to share with you. And it came through watching a documentary on Netflix, which I'd really like to recommend. It's called Night Will Fall. It's extremely brutal, and so I would recommend that, I'm recommending that you watch it, but I'm recommending it also with a very strong warning. But I've never seen anything like it before. It's about the Holocaust, and it's very graphic, and I've been to the Holocaust Museum in Washington, I've heard survivor testimony, I've read books like Night, but nothing hit me like this movie. So I really recommend it, but make sure you're sitting down, as I'm sure you will be. It's called Night Will Fall, and it's on Netflix. Okay, now getting to what I'm here to talk about today. Now imagine that crimes against humanity are being committed in country X. Country Y wants to intervene to put a stop to those crimes against humanity. In other words, country Y wants to stage a humanitarian intervention. Can it? Today, that's the question I'm going to try to answer. So I'm going to begin with some essential international law background, the principle of state sovereignty, the related prohibition of the use of force, and also the concept of international crimes. Once you understand the prohibition on the use of force, you will understand why humanitarian intervention is surprisingly not generally legal. Once you understand international crimes and what we mean by that, you will see why that unlawfulness is, from a moral perspective, deeply problematic. Now, the legal hurdles to humanitarian intervention were the genesis of the responsibility to protect, which is commonly known as R2P. That's what I'm going to discuss in some detail. I'll go over its history and its development, and I'll also talk to you about the content of the principle. What does it actually mean? I'll then discuss some practical examples of R2P, in particular the Libya case, and after that I'll conclude. And I'm going to do all of this in about 20 minutes, so there should be ample time for questions, and I might be able to get us back on the schedule. So beginning with my first substantive point, the international law background. State sovereignty is, as most of you know, a foundational principle of international relations and international law. The idea of state sovereignty is that each state or country has complete and exclusive control over its own affairs, population, and territory. Because of sovereignty, the use of force by one state against another is prohibited under international law. Now, what are international crimes? The term international crime is a legal shorthand or a collective term to refer to certain extremely serious violations of international law. International crimes are crimes that are so heinous that they're crimes against not just the society in which they were committed, and not just against the victims, but they're crimes against the international community as a whole. International crimes are crimes where the victim is the whole world. It's therefore surprising that the use of force to stop the commission of international crimes, in other words, humanitarian intervention, is prohibited. But generally speaking, it is. The issue of humanitarian intervention is one in which the law and morality diverge. While doing nothing to stop a mass killing is obviously immoral, it may not, under international law, be unlawful. Now, I say generally speaking because there are some exceptions. I'll discuss the major exception, which is found in Chapter 7 of the UN Charter. Under Chapter 7, when the UN Security Council finds that there is a threat to or breach of international peace and security, the Security Council may authorize the use of armed force to stop it. So going back to State X, the example I made up at the beginning, where crimes against humanity are occurring, it will be unlawful for State Y to intervene militarily in State X to put a stop to those crimes, unless the UN Security Council expressly authorizes the intervention. Is the UN Security Council likely to authorize State Y's humanitarian intervention? This question was unfortunately put to the test several times during the 1990s. And this brings me to my second point, the history and development of R2P. The international community was confronted with international crimes several times during the 1990s. In 1994, the international community did nothing as almost 1 million people were murdered in the Rwandan genocide. Now here I want to make just a small side note on genocide. States party to the 1948 Genocide Convention undertake to prevent and punish genocide. In other words, if a genocide is occurring, states are legally obligated to stop it. But here you may think of the Rwandan genocide, in which we know the international community failed to prevent. States get out of their obligation to prevent genocide by refusing to label what's going on as a genocide, and that's part of what happened in Rwanda. Now getting back to the story of the 1990s, I mentioned 1994 in Rwanda. In 1995, the international community failed again, this time to prevent the massacre of thousands of civilians who sought shelter in UN safe areas in Srebrenica. In his Millennium Report to the UN General Assembly, then UN Secretary General Kofi Annan presented the challenge as follows, quote, "If humanitarian intervention is indeed an unacceptable assault on sovereignty, how should we respond to a Rwanda, to a Srebrenica, to gross and systematic violations of human rights that offend every precept of our common humanity?" The Government of Canada, Lloyd Axworthy in particular, responded to this challenge in the year 2000 by convening a group of retired political, diplomatic, and humanitarian actors to consider this critical issue. The group was known as the International Commission on Intervention and State Sovereignty, ICISS. They published their report titled The Responsibility to Protect in 2001. It proposed that with sovereignty comes responsibility. Now, it's probably a bit surprising that they were proposing this as recently as 2001, and at that time it was a somewhat radical proposal. But unfortunately, it was. Now, the issue of responsibility raises the question of whose responsibility. According to the ICISS, this responsibility is owed first and foremost by a state to its own citizens. But if a state is unwilling or unable to protect its own population, the responsibility then shifts to the international community. In the words of the ICISS, Sovereign states have a responsibility to protect their own citizens from avoidable catastrophe, from mass murder and rape, from starvation. But when they are unwilling or unable to do so, that responsibility must be borne by the broader community of states. The ICISS report coined the term responsibility to protect, or R2P, and got states thinking about sovereignty as responsibility. Kofi Annan was a strong advocate of the idea of a responsibility to protect, and he played a big role in getting the international community behind it. The idea of a responsibility to protect was formally endorsed by the international community in the 2005 World Summit Outcome Document. So what is the responsibility to protect exactly? This brings me to my third point. The responsibility to protect is a political commitment of UN member states to act to prevent 4 international crimes: genocide, war crimes, ethnic cleansing, and crimes against humanity. The word political is extremely important here. R2P does not create new law that pushes aside the prohibition on the use of force. R2P, while derived from law, isn't law yet. R2P expresses the political commitment of states to intervene to stop certain international crimes. Such intervention still needs UN Security Council authorization. All R2P does is make it more likely that such authorization will be granted. R2P is by no means a guarantee that humanitarian intervention will occur. Remember that China and Russia are permanent members of the UN Security Council and therefore have veto power. So we know that R2P is the political commitment of UN member states to act to prevent certain international crimes. But how are such crimes to be prevented? In 2009, then UN Secretary General Ban Ki-moon published a report titled Implementing the Responsibility to Protect. His report broke R2P down into 3 pillars, which is how R2P is currently understood. Pillar 1 is the enduring responsibility of the state to protect its population, whether nationals or non-nationals, from genocide, war crimes, ethnic cleansing, and crimes against humanity, and from their incitement. Pillar 1 is about the responsibility states have towards their own people. Pillar 2 is the commitment of the international community to assist states in meeting those obligations. Pillar 2 acknowledges that some states, particularly poor ones, may have trouble meeting the Pillar 1 obligation. And so under Pillar 2, the international community undertakes to support states in fulfilling Pillar 1. And Pillar 3 is the responsibility of UN member states to respond collectively in a timely and manifestly failing to fulfill its protection responsibility, including using peaceful measures or using armed force under Chapter 7 of the UN Charter. Now, R2P is often portrayed as being principally about the use of force for humanitarian purposes. In other words, the focus is often on Pillar 3. But the use of force is meant to be a last resort. R2P is supposed to be just as much about prevention, so Pillars 1 and 2, as it is about reaction under Pillar 3. So has R2P been invoked in practice? Have we seen the UN Security Council act further to R2P? This brings me to my 4th point. The first UN Security Council resolution to mention R2P was Resolution 1674 on the protection of civilians in armed conflict, which was issued in 2006. Then, when the UN Security Council authorized the deployment of a peacekeeping force in Darfur, they again mentioned R2P. R2P was again mentioned in relation to Darfur in 2007. The most recent example of R2P in practice is also the most prominent because of implications that case had for R2P itself. And this is the case of Libya. In February of 2009, civilians in Tripoli began protesting Muammar Gaddafi's 41-year rule of Libya. This was part of the wider Arab Spring phenomenon. Protests quickly spread to the city of Benghazi, which became an opposition stronghold. Gaddafi declared his intention to remain in power and to crush all unrest. That same month, in February 2001, the UN Security Council issued Resolution 1970, which affirmed Libya's responsibility to protect its own population. It also imposed an arms embargo on Libya and sanctions on key members of the Gaddafi regime. And it referred the Libya situation to the International Criminal Court. Then the following month, in March 2011, the UN Security Council issued Resolution 1973, which imposed a no-fly zone and authorized UN member states to take all necessary measures to enforce it. In other words, the UN Security Council authorized the use of force in Libya. The no-fly zone was enforced by a coalition of NATO and other states, and their intervention terminated following the capture and killing of Gaddafi by Libyan rebel forces on the 20th of October 2011. This was initially viewed as a triumph for R2P, but it soon became clear that this view was not universally held, and I'll conclude on this. A New York Times op-ed by the journalist David Reif does a great job of explaining why Libya was a turning point for R2P. So I'll quote him. When R2P supporters advocated the doctrine before the UN in the middle of the last decade, they emphasized its non-military aspects and insisted that the use of force would be a rare last resort. Yet in Libya, force almost immediately followed the ultimatums issued to Gaddafi. For all intents and purposes, R2P was NATOized. As a result, everywhere outside Western Europe and North America, R2P is losing what little ethical credibility it ever commanded. This should surprise no one. A doctrine of intervention that both claims the moral high ground and clamors its universality, but under which the interveners are always from the global north and the intervened upon always from the global south, is not moral progress. It is geopolitical business as usual. Another problem was that intervention in Libya ultimately resulted in regime change. Some powers, particularly Russia, felt that R2P was used as a cover for regime change. And since Libya, Russia has used its veto against R2P and other actions like it. Syria is, of course, a case in point. Just last month, Russia and China blocked the UN Security Council from imposing sanctions on Syria for its use of chemical weapons. Some people say that R2P is now dead, but I don't think it is. I think it's in a coma, which is why I wanted to tell you about it here. The more people who know about it, the greater the chances of R2P waking up. I think the first step in waking R2P from its coma is to focus on pillars 1 and 2. To remember that R2P is also about supporting less developed countries in protecting their own populations. I don't think R2P can help the situation in Syria because of Russia's veto power, but I do think that it might have a role to play in preventing the next Syria. Thank you.
Yeah, rather, I just think it's important to remember that NATO originally began as a defensive military alliance in Western Europe. When you say that something is NATOized, that's the original mission of NATO. It is not to intervene in other countries. Out-of-area issues were always contested at first, and I think that as a defensive military alliance, the goal was to prevent a third conventional war in Europe that would cause I don't know. I think the Second World War was, I've seen figures between 80 and 90 million deaths. The Second World War is originally referred to as the war in Europe in Canada in the parliamentary documents. So I actually think it's a very successful defensive military alliance, however much conventional war, weapons or intermediate ballistic missiles are contested by parts of the population. I think the absence of war in the majority or the central parts of Europe where NATO exists has been a success. And my second question is, and I don't think you're going to like it, is I would like a précis on what you were going to say about the African Union. I promise to do my best to understand that I disagree with your husband.
Okay. Okay, so to respond to your first point, yeah, I didn't mean to impugn NATO at all. All I meant to say was that NATO is it's an alliance of a certain set of states, and when they say that I was quoting, and when that author says that R2P has been NATOized, I think what he meant is R2P has become aligned with Western states, with Western Europe and with North America, as opposed to being a universal norm. It's become something that the West can use as a cover for its own agenda. That's what I meant. I wasn't making a comment on NATO. And on your second point, sure. So while we were having, while R2P was being developed, actually while the International Commission on Intervention and State Sovereignty was working on their report in 2000, that was a really pivotal moment for regional governance in Africa, because it was around the same time that the Organization of African Unity was transforming into the African Union. The African Union came into being in 2001, and it replaced the OAU, which as its predecessor was very much focused on decolonization and the consolidation of post-colonial states in Africa. But then in 2001, they switched over to this new organization, which had a different set of goals and was much, much more focused on human rights. Now, under the OAU Charter, a very foundational principle in their charter, but also just governing the way they did business, was the non-intervention in the internal affairs of member states. And that was kind of a cornerstone of how the OAU operated. That provision, which is a reflection of state sovereignty, is also in the Constitutive Act of the African Union. But in addition to that provision, there's a further provision at Article 4H, which is called the Non Indifference Provision. And what that does is it gives the AU's Assembly of Heads of State and Government the authority to authorize intervention in respect of war crimes, crimes against humanity, and genocide, to put a stop to those crimes. Now, there's a bit of that, which that then raises the issue of, well, what about the Security Council, and doesn't the Security Council have a monopoly on that decision-making power? And the answer is they do. The way the AU sees it is that because the AU is closer to the ground and closer to the issues, the AU Assembly of Heads of State and Government should be able to authorize intervention in Africa and then seek ex post facto authorization from the Security Council. So that's the legal framework now in Africa. We have this idea of non-indifference. In practice, though, the AU has seemed to favor diplomatic modes of intervention. In Libya, it played out especially starkly because you had the UN authorizing a no-fly zone and so authorizing a more military solution to the conflict in Libya, while at the same time you had the AU's Peace and Security Council acting in relation to Libya, and their action was to send a delegation or to try and send a delegation of 5 heads of state to Libya to resolve the crisis diplomatically. In the end, their heads of state couldn't get there because of the no-fly zone, and so that actually created, there was a lot of back and forth criticism between the AU and the Security Council because the AU was trying to solve it through their own means, but they couldn't because of this no-fly zone. Sometimes their diplomatic efforts have worked, though, such as in Kenya. The AU Peace and Security Council sent a mission of heads of state to Kenya after the post-election violence there, and those heads of state were successful in resolving the violence there. Yeah, Jennifer.
Hi there, my name is Jennifer Petrella. I'm from the Pierre Elliott Trudeau Foundation. Thanks very much, Marina, for that talk. That was really very interesting. I have 2 questions. One would be about the interplay between regional human rights protection mechanisms and international ones. So you referred earlier to the kind of lack of legitimacy that international mechanisms can have regionally. So I'm curious as to how you see the future of human rights protection mechanisms, given the kind of fractionalization, if you will, of the world increasingly today. And then the other question I have regards protections. You know, you refer to the first two pillars of R2P being more protection-oriented and the third being more intervention-oriented. And you referred to an example of how an intervention was justified using R2P. If you could give us a couple of examples of how actualized, that would be interesting. Thank you.
Okay, so to your first question, it's a really interesting question, and it's very timely as we're seeing African states withdrawing from the ICC, in large part because they see the ICC as focused on Africa or as targeting Africa. I mean, I personally don't see it that way. I think the ICC is responding to where the crimes are occurring, and it just so happens they're happening in Africa. But again, this actually, and I didn't want to get to your second question right away, but it does go to your second question. And if there is a preponderance of international crimes occurring in Africa, it's perhaps because those preventative pillar 1 and 2 prongs of R2P are not being realized. Certainly, I think pillar 2, the international community's responsibility to assist states in protecting their own populations, there could be a lot more. Unfortunately, what it comes down to is that state action is governed by state interests, and states are governed by politicians who make decisions, often, unfortunately, in their own interests. And politicians' individual interests and states' interests often don't align with assisting other countries in protecting their own populations. And so I think there's kind of a fundamental disconnect. And that's why I actually think events such as this are so important, to bring these issues to the broader public and to make the electorate care about these issues. That's the only hope we have, I think, of aligning the protection of vulnerable people around the world with the way powerful countries do business as usual. Politicians in places like Canada need to know that the people who keep them in power care about these issues. And I think only when that happens will we see countries fulfilling their Pillar 2 responsibility to assist countries in Africa and other less resource parts of the world in meeting their Pillar 1 obligation under R2P.
Hi. My question relates a little bit to the question that was before, because, you know, it's responsibility to protect citizens, right? So it made me think about that key term, citizen. What are the limits to R2P, for example, to people that are not considered being citizens in a country, and for who the country doesn't have necessarily a legal responsibility? So how do we tie, for example, in the case of a crime against humanity, it's a crime against humanity, right? That doesn't have borders. Mm-hmm. But what if it was perpetrated against people that are not considered citizens in a country? Okay. I'm not sure if you have any thoughts.
Yeah, no, I'm really happy you asked that question because it's a really important point of clarification. So the Pillar 1 responsibility of states to protect their populations, it's actually to protect their populations, citizens, and non-citizens, so everyone on their territory. And I'll also point out that human rights obligations are owed by countries to everyone on their territory. Most people don't know this, actually. There are very few human rights that are limited to citizens. It's really only the right to political participation and the right to run for public office that are limited to citizens. When you're in a country, even if you're not a citizen of that country, the government of that country owes you your human rights. They have a duty to guarantee your human rights. So if you're a Canadian in the States, while you're on U.S. territory, whether you're there lawfully or not, the U.S. government has an obligation to guarantee your human rights to you, just like they do to any one of their citizens. And the reason for that, the kind of natural law reason for that, is because human rights flow from our dignity as human beings. They're dignity-based. They're not citizenship-based. We have human rights because we're human. And so conceptually, it actually wouldn't make sense if human rights were limited to citizens. Now, from an enforcement perspective, of course, it is much easier to enforce your human rights if you are a citizen of that country, because realistically, if something happens to you while you're in a country temporarily, you're probably not going to bring legal action to protect your human rights. But at least conceptually, it's important to know that you do have human rights wherever you are in the world. And governments, of course, it's also important that, of course, governments know that. Governments know that they have this duty to everyone on their territory, not just their population of citizens.
Thank you.
There's no more questions?
Are there any more questions? Please, we'll take one.
Ask a question, thank you. I'd be interested to know about how prevention rather, is conceptualized either in the original R2P concept or in Ban Ki-moon's 2009 kind of reworking of it, because you have evoked protection as a prevention as a more hopeful arm of R2P, and I think that that's right on, right? We've seen how Syria just seems unstoppable, but it could have been prevented.
Yeah, it's not. I think that a range of measures would be allowed. Like development assistance is obviously the main avenue through which prevention would be. If we're talking about more well-resourced countries helping less developed countries, it would be through development assistance, and that of course could run the gamut of funding education or funding women's rights initiatives, or a range of things. And then of course there's the prevention responsibility that states have that a state has towards its own population. So we're not talking multilaterally, just in terms of the citizen-state relationship. And there, human rights protection is really, human rights, we have civil and political rights, we have socioeconomic rights. They run the gamut, and I think the best kind of list, if you will, of the important issues that can foster prevention efforts would be just ensuring that human rights are respected, are promoted, protected, respected. So the range of programming that a government might have to address those rights would be the a government's human rights protection programming, or the way in which human rights inform their policy-making process and the legislative process. I think that would be the same. It's one and the same, really. There's also a distinction to make between when the state is the author of international crimes versus when the state just fails to protect people from crimes. So there's kind of degrees, right? The answer is different depending on whether we're talking about a state, a pariah state who's committing those crimes against its people, or whether we're talking about a state that's just not fulfilling its protection responsibility to protect its citizens from threats that might emanate from non-state actors. So I hope I've answered your question. Okay, thank you very much.